Thanks very much, Jonathan. Yes, I'm not going to talk about, specific waste regulations. I have put an appendix in the back of the paper in relation to the waste regulations that have come through, and actually Duncan Lawrence kindly sent me through waste regulations that were just published, which he sent me yesterday, which I'm not going to talk about, but Duncan said he'd be happy to answer any questions later on, didn't you, Duncan? I'm not either going to talk about what you might say is the old chestnuts the new government are going to have to grapple with. Somebody needs to make some decisions, I think, to bring some certainty to a sector which has suffered from a lot of uncertainty over the last 3 years in the whole kind of public-private sector side of things, in terms of the of waste licensing, access to the Environment Fund, domestic waste collection, the triple function that local authorities have in terms of licensing, enforcement and provision of waste services and so on. So instead I am going to concentrate on this Neffin case, which has been already talked about both by Conor and to some extent by Jonathan. It is a case in which I was, with very able barristers obviously, advising the director respondents, and it is a case which is ongoing. And so in that context I'm going to focus on the decision, but I'm not obviously going to go in too much to any of the facts. Sorry, just in terms of the next slide, where's the thing?
You can use the mouse or else.
Okay, just go that way.
Back there.
So I'm going to focus instead, as I say, on this High Court decision involving the polluter pays principle. And the polluter pays principle comes from, as Conor said, a council recommendation. Now, a council recommendation is a different creature to a regulation or a directive, and this becomes important. A regulation is a type of instrument which is it's mandatory. It's already effective, if you like. Directives, as you'll probably know, are directly effective. They're instruments that are aimed at member states who are obliged in turn to implement them. But recommendations are a slightly different creature, and this is something, as I say, I'll come to in more detail. But this polluter pays idea comes from this council recommendation back in 1975. And it talks about, for example, eliminating pollution, reducing it so as to comply with standards or equivalent measures. A lot of it is concerned with setting standards and then imposing charges for people who don't comply. This is referred to in the Treaty of Rome, as obviously amended. It was Article 174 originally, which talks about environmental damage being rectified as a priority at source, and that the polluter should pay. So that's what the Treaty of Rome said, and as I say, it's since been amended by virtue of the Lisbon Treaty. It's a different number now, as happens quite regularly, but that's where it gets mentioned. You then have it traced through, as Conor mentioned indeed, that it's referred to in the waste directives, 75/442 being the original waste directive, in the 91/156 one. It's also in subsequent waste directives, including the most recent one, and in the landfill directive. And many of these directives refer to the polluter pays principle in their recitals. For example, in the 75/442 one, it says, whereas that proportion of the costs not covered by the proceeds of treating the waste must be defrayed in accordance with the polluter pays principle. So that's obviously a long time ago that this is a key feature, if you like. Article 15 of the 91/156 directive says that in accordance with the polluter pays principle, the cost of disposing of waste must be borne by the holder or the previous holders. And this has resonances with the Irish ISPAT decision that Conor was talking about. Where this polluter pays principle comes through then into Irish law is in the context of the Waste Management Act 1996, and that act was designed to transpose the directives. But insofar as it talks about the recommendation, it defines the polluter pays principle in the interpretation section, the definition section, if you like, and that's in section 5. So it says in section 5 of that act, the polluter pays principle means the principle set out in the council recommendation that I've just talked about. And there are other references to the polluter pays principle in the Waste Management Act, but actually not very many. There are references to it in the context of the preparation of waste management plans and hazardous waste management plans, where the polluter pays concept has to be borne in mind. But there's precious little other reference to the polluter pays principle there at all. And the reason I brought up there section 9 Section 9 deals with criminal liability. Sections 57 and 58 are the civil clean-up remedies that Conor spoke about. And in Section 9, which deals with criminal liability, it specifically anticipates a situation where enforcement can be taken not only against the company, but also against directors, managers, secretaries, other similar officers, and even shareholders. So in a civil context, it's really quite explicit. It talks about the fact that, OK, the company may be responsible, but these whole rake of other people may also be responsible if it's proven that what has happened due to their act or neglect. And this is a contrast that comes through in the legal submissions I'll talk to you about, and also in Edwards' decision. So in the Fenton case, which Conor referred to, essentially, as Conor said, this is concerned with one of these sites in County Wicklow. In fact, David Sweetman, who's the law agent in Wicklow County Council and long-suffering, was involved in this case, obviously, which concerned a site called Coolamadra. And the facts of this case were around the fact that illegal dumping, but particularly medical waste, had been discovered in Coolamadra. And, as you'd expect, most of Wicklow is pretty scenic, pretty nice, and not supposed to have been used for illegal dumping, but many of it was. And the defendants were the owner of the site, a Mr. Fenton, hence the name of the case, and Dublin Waste, which was a company that was found to have hauled waste into this site, together with two directors of Dublin Waste, Louis Moriarty and Eileen Moriarty, who were the directors of the company. The case is number 2, and from memory, the number 1 part of the decision was Dublin Waste attempted to bring in 2 hospital customers of theirs to essentially say, well, if medical waste ended up there, it's not our fault, it's because our customers gave us medical waste and it was misdescribed. And the judge, O'Sullivan, said that there wasn't any mechanism, sort of a procedural issue, there was no mechanism to bring in a third party in the case. So in this case, which was heard, really quite quickly, on the basis of affidavit and oral evidence as well from memory, it was concerned with clean-up orders being sought by Wicklow County Council against the landowner, the company and the company directors. And this is in the context not only of illegal dumping, but of illegal dumping causing environmental pollution. And the application sought clean-up orders against the individual directors because there was a concern that the company wasn't going to be able to foot the bill, basically, to clean it up. And like a lot of these cases come down to money. Who's going to pay for this? There's a problem there, it needs to be fixed. Who's going to pay? I think of relevance is the fact that in that case the judge looked at what the role of these directors was. Were these directors who were directors on paper but really had no involvement in the business or otherwise? And he said that there's a direct involvement, that in the case of Louis Moriarty, he supervised the operations at the transfer station. So when the waste came into the transfer station, he supervised what came off lorries, what went on lorries, and therefore what went to Coolamadra, an active role. And he said that Eileen Moriarty did the books. So she knew exactly what was going on as well, and that both enjoyed the fruits of the company's earnings. These individuals, rather than either the applicant or the community, should be made to pay. That was essentially what his role. And what he said was, in looking at the polluter pays principle, which he traced through, he referred to the recommendation, he noted its reference in many of the directives, he referred to the Waste Management Act. He basically said, look, for me to make some sense of Irish law, to make it compatible with what we should be doing in European law, then I have to lift the corporate veil. So what he said was, in conclusion, to give effect to the polluter pays principle, I must lift the veil of incorporation and impose fallback liability for clean-up. In other words, to have not allowed that would have frustrated the intentions of the EU, is essentially his conclusion. And that remained the position. 2 other cases, Frank Clark decided a case, Cork County Council in O'Regan, and Peart, Mr Justice Peart in Laois County Council in Scully. Now, none of these cases went to the Supreme Court. My understanding, I'm open to correction, is Coolamadra got cleaned up. The site in the O'Regan case got cleaned up. And the Scully case, I believe, is still before the courts and is still quite active and a problem. But the position is that none of those cases ever went to the Supreme Court. And then we come to this most recent case. So in this case, the agency sued Neffin Trading Limited and other corporate respondents and 4 director respondents in relation to alleged illegal dumping. And those proceedings were issued in 2009, and in them they sought liability to be imposed against the company and the directors. And they sought liability against the directors on a number of bases, including this fallback liability basis. That isn't actually the only basis on which they're looking for it. But in the context of that, we argued that this preliminary legal issue should be carved out and heard first, and the court agreed to that. So the preliminary issue that went before the court, in a fairly sort of sterile, factual circumstance, if you like, is whether on a true construction of the law, a fallback order may be made against individual directors and or shareholders of a corporate entity under the provisions of the Waste Management Act. So that was the question he was deciding. So what I want to do is I'm just going to tell you roughly what the 3 parties arguing the case before the judge, what essentially they said, and then what the judge decided. So acting for the director respondents, we made 4 points, or 5 points. Essentially what we said, first of all, is you have to contrast the explicit wording that I talked about in section 9, where it is explicitly anticipated that liability can move beyond the company to directors, officers, managers and shareholders, to sections 57 and 58, which is no wording like that at all. Sections 57 and 58, if you apply a literal rule of interpretation, which we said is essentially the rule of interpretation you generally apply, says that the holder of waste should be liable. If the holder of waste is a company, it's the company that's liable. It doesn't anticipate or provide explicitly in any way to look behind that holder to somebody else. We said that therefore there was no intention expressed in the legislation on the part of the Oireachtas to allow the lifting of the corporate veil in all circumstances under section 57. So whilst the corporate veil can be lifted under general law, and Conor referred to that, we said that section 57 doesn't provide for that. And what is being argued for is that section 57 permits the lifting of the corporate veil anytime, absent fraud, absent an intention to prevent a court order being implemented in any circumstances whatsoever. That's what was being argued on the other side in support of Fannon. We said that this polluter pays principle is not binding, it's not directly effective. It's contained in a council recommendation. It's an idea, it's something that we should all strive through, but Ireland had to actually take a grip on the polluter pays principle and decide how to implement it in Ireland, and that had not been done. That actually there was no transposition of that principle into Irish law at all, and that as a result we said that Mr. Justice O'Sullivan in Fannon had gone too far, and a number of commentators had referred to this before, and in fact Dr. Yvonne Scannell had said in her book that Mr. Justice O'Sullivan went further than any previous High Court in Ireland in expressly endorsing, interpreting and applying the polluter pays principle almost as if it were a rule of law rather than a political legal principle, the status of which is hotly debated. So the agency obviously responded to that and made quite a number of points, some of which there's inevitably crossover from what we said. First of all, they said, look, the High Court has decided this 3 times already. You're a High Court judge. You basically have to follow what your previous colleagues have said because that is an essential principle of our law, which it is. It's not absolute, but generally speaking, courts of equivalent jurisdiction follow each other. They said that Section 57 of the Waste Management Act is very similar to the planning injunction. It used to be Section 27, which was the one applicable at the time Section 57 was enacted. Now it's Section 160. And they said in Section 27 planning injunction cases, the courts have lifted the corporate veil before. You should feel able to do so here. It's an analogous situation. They said that by the reference in the interpretation section to the polluter pays principle in Section 5, that the recommendation had been properly transposed. They refer to the Commune de Mesquier ECJ, as it then was, decision, in which the polluter pays principle had been used in order to adopt a very wide and flexible approach to what a holder of waste and a producer would be. They refer to Section 52(2)(d) of the EPA Act, and it's relevant because it requires the agency to take account of the polluter pays principle. In carrying out its functions, the agency shall, there's no discretion here, have regard to the need to give effect insofar as is feasible to the polluter pays principle. It was therefore argued that the agency was statutorily obliged to give effect to the polluter pays principle, and in doing so, to apply for and obtain as necessary fallback orders. They said that in the context of the waste management or waste framework directives, there were various articles which made it clear how important this principle was, and that the piercing of the corporate veil was justifiable in order to meet those objectives, and that O'Sullivan was correct. Now, slightly unusually, we were heard before Edwards over maybe 2 days, and he reserved judgment. And then he called us back maybe 5 months later to say, look, you should have all been asking Ireland and the Attorney-General to make submissions here, and you know, I don't know why you didn't, but I'm going to do it now because there's a clear issue of transposition here. And so he directed that Ireland and the Attorney-General deliver legal submissions, which they did. And essentially the legal submissions of the Attorney-General focused on 3 issues. One was this principle we've talked about before, High Court following the High Court, a principle of stare decisis that Conor referred to. Second of all, they said that as far as they were concerned, the waste framework directives and other waste directives, including the landfill directive, all of which refer to the polluter pays principle, that those directives had been properly transposed. There was no issue of transposition here as far as the Attorney-General was concerned. And thirdly, that O'Sullivan was correct in the way he interpreted Section 57. He took what's called a teleological approach. He read Section 57 in a way to make it compatible with the polluter pays principle, and the Attorney-General said he was right to do so. A number of months passed, and on the 3rd of March then, Edwards gave his decision, which, to be fair, was kind of consistent with what he'd indicated when he called us back to ask for submissions from the Attorney-General. So he took a pretty thorough approach. He first of all looked at this whole business of statutory interpretation and what's the right approach when you're looking to interpret Irish law in the context of EU law. He noted that there is a dispute as to the status of the polluter pays principle in EU law, and the extent to which those directives which the 96 Act were enacted to transpose, to what extent they actually require the application of the polluter pays principle, and how. So the polluter pays principle, nowhere, as you'll have seen, does it refer to piercing the corporate veil or looking through limited liability. So the enforcement of the polluter pays principle is essentially a matter for Irish law. And so he was looking to say, well, what has the Irish legislature decided that we're going to do about the polluter pays principle? The status of it, as he said, is he was satisfied that it is a key principle in environmental law. And really where he differed from O'Sullivan is the extent to which it had been incorporated into Irish law and what that meant. In his view, insofar as he ends up differing from O'Sullivan, he said, look, I think what happened here is that, in my view, Mr. Justice O'Sullivan concentrated too much on what the EU intended and too little on what the Oireachtas intended, as understood by the plain words, if you like, in the 1996 Act. And he said that whilst a purposive teleological interpretation is legitimate, so trying to ensure that the Irish law is read in such a way that it makes sense is fair enough, you can't go so far as to import words that aren't there. That's essentially what he was saying. So in summary then, he comes up, he identifies 5 reasons for disagreeing with Mr. Justice O'Sullivan. So he said that there was very limited incorporation of the polluter pays principle into Irish law. He said, look, you know, there's references to it in the directives and articles and preambles and so on, but if you look at Irish law, there's very little there. From what I was even saying at the beginning, it's in the interpretation section in Section 5 of the Waste Management Act. There's 2 small references in 2 subsections on waste management plans, and there's a reference in the EPA Act in terms of the functions of the EPA. There's very little else. He contrasted the explicit reference in 2260 and 26.2d, they're the ones about the waste management plans, with the fact that there's nothing in Section 57 and 58, either about the polluter pays principle and certainly not about piercing the corporate veil. He said that no interpretation approach can justify altering fundamentally the limited liability principle, and that this is going back to sort of legal certainty, that the limited liability principle is a very important one in the civil law in the common law jurisdiction, and that it shouldn't be changed absent express statutory power. And he contrasted the wording for the criminal liability under Section 9 with the civil clean-up liability, where in Section 9 it's very clear that liability can go through a company to directors, managers, secretaries and, as I say, shareholders. In summary then, he said as follows: "It seems to me, therefore, the Waste Framework Directive has not been properly or adequately transposed insofar as enforcement is concerned. Insofar as the existing enforcement provisions contained in sections 57 of the 96 Act do not in fact allow for the making of fallback orders against individual shareholders, directors of a corporate entity. In these circumstances, I must answer the preliminary question in the negative." So the Irish courts don't have jurisdiction. That's essentially it. Now, this case may yet be appealed. The decision has to be made by next week. I'm sure the decision's already been made, but I'm not aware of whether the notice has been filed yet. It has to be served by next week. Amending legislation probably is required. Whether there's an appeal and amending legislation, I mean, who knows? But the case is ongoing. I mean, this isn't the end of the case by any means, but it is one aspect of the case in which Edwards has made his decision, but as I say, that decision may yet be changed if it goes to the Supreme Court, this issue never having gone to the Supreme Court before. Thanks very much.